So without further ado, I would like to introduce you to our first guest speaker, which is Connie Lee, who will be providing us with a brief introduction into the Australian legal system. So Connie is a lawyer and a certified interpreter of Australia, and is a lecturer in law in China. She's had over 8 years' experience in legal interpreting here in Brisbane, Sydney and Melbourne, for criminal, civil and administrative matters. So within federal courts, state courts. So yeah, very experienced, and we are really privileged to have you speak. So thank you, Connie.
I think it would be very helpful for our interpreters, myself as well, just to get prepared in advance about the court hearings, particularly, right? We walk into the court, we walk into the courtrooms, right? So everything seems quite formal and daunting. So I'm an interpreter and I'm a lawyer, so I'm thinking, what's important for us to get some idea what's happening. So therefore, I think it would be useful just to know a bit background information. So that's for my presentation. So now I would like to go to the next page. So we know the court proceedings in countries like in common law system. I don't know if you have heard this word, common law system. So it's comparison to other law system called a civil law system or inquisitorial system. So like in UK, USA, and Australia, New Zealand, Hong Kong, they're all in common law system, right? So the origin is from UK. So the great British colonies, when they conquer the world, they spread their legal system as well. Therefore, they sort of inherit from them. So therefore, we have a common law system here. So the common law system basically is in adversarial in nature. So this means each party to the case, they presents their own arguments and evidence in support of his version of the events to the court. And the court can decide whether the party that commenced the proceedings has approved the version of events to the relevant standards. Of course, we'll talk about the relevant standards later on in civil and criminal cases. So basically, when you walk to the court, so who can decide what the issues are? So basically, it's the parties themselves. The court can only make decisions on the issues that the parties raise to the court that are in dispute, and decide only on the basis of the evidence and the argument presented to the court by the parties. So the court itself sounds very serious, the judge sitting there, you're honorable, and anyhow, they cannot conduct its own investigation. They cannot just make its own version of the events. They have to listen to the parties. You say your story, you prove your story, right? So it's quite different from inquisitorial system like in Germany or in mainland of Europe. Switzerland, and like in China, it's a civil law system. So basically in that civil law system, the judge has more power. They can decide, they have more active role in directing. They can decide, to make the inquiries. I can decide what the issues are. Therefore, I want to investigate further. Then you provide evidence to prove, to serve the court. So that's a different legal systems. They all have pros and cons somehow. So that's the way it is. That's how our civilization ended like that. We don't know why, how, however. So that's the case. So now we move to the issues, that's what we said. We walk to the court, we have the topic, we have the issues. Who brings the issues? What are the issues? All right, we go to the second page. So the issues are the question of laws or fact that the court determines. The issues itself, they can establish the framework of the law of the evidence will operate. So that's a framework. So we come to the court, we come here. plaintiff and also the defendant, or they come here just for the issues, right? Okay, we go to the second page, second one. So coming to the issues now. So the issue is, how are you going to prove your case? Prove what you said is right or wrong. Have you borrowed money or not? Or in criminal case, this person has murdered this person or not? Or no? It's a question mark. So who is going to prove? So there is a legal burden of proof. Sometimes we're in the court and we are standing where they interpret for the witness, very likely. So, or sometimes for defendant, or sometimes for applicant. So they as well, when they're talking their story, so they are doing some job for themselves. So it's the legal burden of the proof. They have the burden on the shoulders, the legal burden of the proof. Okay, so it's the party has to prove or disprove a fact in issue. So in criminal cases, so basically the Crown is doing has a legal burden of proving all the elements of the offence. So sometimes someone, even it's murder or kill someone sometimes, maybe there is one element is not there because this person is insane, whatever. Under exceptional circumstances, the person can be, walk away and not guilty. So the prosecution has to prove that, all elements of the offence. The prosecution also has the burden to negating that defence rests on the party. So basically the person who is sitting on the accused or the defendant, so basically is innocent until proven guilty. So the accused sitting there, they have an evidential burden is to point what? Point a reasonable doubt. So you only need to prove there is a reasonable doubt there, so in your case, because the bar, then we're talking about the standard of the proof, so in criminal cases, is beyond reasonable doubt. Okay, beyond reasonable doubt, then if there is a doubt there, I didn't murder him, or, in the dark weather, or it's raining, how do you know that person murdered that person? You have reasonable doubt, therefore I can walk free. So sort of thing, that's a different standard, very high. It's in common law system, the criminal burden of the proof is setting very high. So it's really hard or difficult to put this person in jail or found is guilty. Somehow it's also related to their philosophy, so the human rights protection, the procedures, due process, that sort of thing, So in civil law systems, so they're slightly different. I'm not saying that human rights protection is way lower, but they're different. So if you're referring to some other developing countries or some other countries like China, so they may have a higher, very efficient in maybe to get the criminal in jail, that person did something. So, in a few months, this person is in jail. However, in Australia, you found this person stole something until the person got into the jail. It's 2 or 3 years' time, so it's different. So, So you have a different sides of the pros and cons, as I said. Okay. In civil cases, however, the legal burden will be the parties asserting the claim to prove all facts are essential to the claim. So the legal burden of the proof is both on the two parties as well. Now we're talking about standard proof, as I said, in criminal cases beyond a reasonable doubt, right? So like, that famous case in United States, in Simpson, right? The celebrity sports star, whether they killed or murdered the wife after a long trial, and then found it's beyond a reasonable doubt he can walk free. However, in civil cases, it's way lower. So therefore, in civil cases, the victim got a very high compensation from that guy. So that guy walked for free, probably bankrupt at the end from all the whole journey. So interesting. I think he's the barrister for the Simpson is the father of was a famous celebrity. What's her name? Yeah, that's the one. So that's the story. So basically, so that's a standard of proof. Then it's very high. beyond reasonable doubt is because of there was a doubt of the gloves. Whether that gloves, he has a big hand, he can fit into that gloves. So that's standard of the proof. That's in that case. So now we're talking about evidence. So evidence basically is the materials you are going to present to the court to prove your case, right? You need something to prove. So there are different sorts of evidence. There are information, there are documents, or other materials. I don't know if I can go in a little bit more details. Let me check my time. So I'll go very quickly. Just the example, say what's the evidence in a certain case. So just for example, in a case involving a traffic accident, so there is a dispute about facts such as how fast the car was traveling or what the weather or visibility conditions were. So evidence to prove such facts might be drawn from sources such as eyewitness accounts or weather reports or the state of the cars, such as the nature of the damage to the vehicles and the length of the direction of the tire marks on the road. So there are all kinds of evidence can be presented to the court. However, not all the evidence can be considered or admitted by the court. So the one which can be admitted is called admissible evidence. Now, some evidence you cannot be admitted into evidence is called inadmissible evidence. So sometimes a great piece of information. So, the guy said, I did kill this person at such a day because and such. You said, oh, great, that's a great piece of information that will be found him guilty. However, maybe the person who conducted the interview, the police in legal procedure didn't follow the due process. Therefore, it's not admitted. So that's inadmissible evidence. So that's very different. In Australia, it's comparing because I have a Chinese background, so I'm seeking a Chinese law background as well. So probably in Chinese law system, so basically this person, you will be job dead once you said that. So they'll use these words to be against you. So that's very different. So we really focus on due process. We're very focused on the procedure. You have to follow the procedure. Even you reach the outcome, you have to follow the due process. So basically, the person comes to the court, they're not looking for the truth or the ultimate truth. They're looking for the argument. Who can present the argument? So in favor of who? Which party? Okay. Now, let's talk about the examination in chief. So now we have the issue. Now we have the parties. Now we have the evidence. Now, how are we going to play? How are we going to show the whole thing? So, okay, to start, there is every time when we walk into the hearing, so at the start of the court, the judge and the barrister, the two parties, they will have a chat about the procedures, have a very short, brief conversation. And then you start. Okay, everybody's ready. Let's go. Examination in chief. Examination in chief basically is led by the party who called the witness. So, such as the prosecutor, they may call their own witness. So some eyewitness said, I saw that person killed someone a certain day. That's their witness. So the prosecutor will ask the person, examination in chief. So the examiner may ask questions with a purpose. What purpose? To eliciting factual answers within the personal knowledge of the witness or of the opinions that the witness is qualified to give. So when you're talking about the opinions, so basically you are talking mainly referring to the expert witness. So they can give the opinions based on their qualifications, such as this person is a psychologist for how long and such and such. So, or this person is a medical doctor for how long, therefore they can give the evidence such to his opinion, and this injury is caused by such and such, and that sort of thing. So that's examination in chief. So you tell the court, you start to run your show to show why you're here, so you present your story to the court. Okay, now, that's you one side of story. How can you get the other side to say jump in and say, I found something. Okay, that we call them cross-examination. So basically, it's the party not the one to call the witness. That's the if you say prosecutor, that's called an examination in chief. Then the defendants or the accused barrister, they will jump in. It's their turn to ask a question of the witness. They say cross-examination. So, yeah. So the objective of the cross-examination are generally to elicit facts favorable to the cross-examiner's case. They want to find the points which is good for the accused. I didn't murder that person. I will find some things tricky there. Otherwise, there was another point is, firstly, you can point into the facts, and then on the other part, you can say this witness is not reliable in his evidence, or maybe not credible because of the matters such as bias, corruption, or lack of veracity. So from the facts part and also from the credibility part. So sometimes in the hearing you can say, this witness is not, the credibility is an issue there. So if this person fails and the jury can see that and watch that, and they'll give them very less weight on this person's evidence. So that's cross-examination. So the prosecutor asks the witness, and then the defendant's barrister has to cross-examine, and then now it's turn for the prosecution again, so re-examination. Why are you coming to re-examination a person again? So it's give them a chance to say the purpose is to elicit evidence which explains or qualifies, which have emerged in cross-examination. So there is a distortion or incomplete account of the truth. So they give the Crown another chance to re-examine the person so if the cross-examination has distorted the story, so now it's another chance for you to get the story back. So it's re-examination. So at our court, interpreting, you can see they take turns to talk. So that's how. Okay, here is open to the public. As we all know, probably when you walk to the court or tribunal, usually it's open to the public. You can see all the students coming, occasionally maybe journalists coming. Anyway, so anyone can walk in. However, sometimes some cases is not open. For example, you may have some sensitive issues or public interest. I don't know, for the Melbourne, the trial for what's one, George Pell? That case, I don't think it's public, right? So for reasons, because he had two cases going on, then I think that one was not open to the public. So, and even the result was. There is a court order; it's not allowed to publish in Australia. However, you got the news from Facebook from America. Anyhow, you found it's guilty. So, okay. So exceptional cases. So why hearings have to open to the public? So basically, again, it's a due process. We want to see the justice to be done. You want to see the justice to be done. So that's a way to sort of like it's related to more like natural justice. Natural justice. I want to see it's fair. It's like a common sense. I want to see it's been done. It has to be fair to every party. So jury. So we know the jury. So we say many movies, and also we have a court interpreting comes 12 people in criminal cases. So basically, in criminal and civil, they both use juries, but more common in in criminal cases. So. Jury's job. What jury's job? What can they do? They're just layperson. They're walking on the street. You grab them in and sit there. You can decide someone's fate. Oh, great. So what they can decide. So basically, they are the ones to decide whether the defendant is guilty beyond reasonable doubt. So basically, the judge still direct them in terms of law sort of concept. So is that a reasonable doubt? What do you think from your heart, from your brain, from your mind? So they can find this person is guilty or not. So you can see in the movies, they come to read what the verdict, so they all say is guilty. However, they do not decide the sentence to be imposed. So it's the judge to decide, okay? Now, we move on to criminal proceedings. Okay. Criminal proceedings, which is a big thing in our whole society, right? Well, firstly, we want to be safe in the society. Apart from prosperity, you want to earn more money. Safety is the first. So criminal proceedings we're talking about. So there are some minor offences. We call them summary offences. Shoplifting. The teenager a bit naughty, doing those minor things, and so usually you trial without a jury, usually by magistrate. You go to Brisbane Magistrate Court, you go to Redcliffe Magistrate Court, Sandgate Magistrate Court. It's minor offences. So with summary offences, the defendant is brought before a magistrate who hears and determines a case. The majority of the summary cases, who is standing there, who is prosecuting them, or who is the one to accuse them. It's the police, right? The police with uniforms. In Brisbane Magistrate, you can see the police walking in and out all the time. So they lay the information to prosecute the proceedings. So Magistrate Court in Queensland is the first level of the court system. So most criminal cases are heard there. So indictable offences, this means more serious, okay? Usually they go to district court or Supreme Court. So in district court, they deal with a serious criminal case such as rape, armed robbery, or fraud. So the highest state courts, Supreme Courts, they hear the most serious criminal cases, including murder, manslaughter, serious drug offences. So yeah, it's heavy stuff, right? So in the criminal cases, the one who is standing there talking prosecution, the Crown or DPP, there's one in a representative of the state. So they are on the behalf of the state, Australia. So they're prosecuting criminal offences. So now, once we start the criminal proceedings, so first, usually the accused must enter plea. They will say, plead guilty or not guilty. So by your experience, you probably notice that they will ask them to plead guilty. Usually, if they want to go to trial, they say, I'm not guilty. So let's go have for a fight, which is trial. So sometimes I want to plead guilty. I just want to get a lesser or lenient sentence, easy. So we have a deal. So that's another case. Committal hearings. So with serious offences, usually there is a committal hearings. But committal hearings, as I said, serious offence usually in district court or Supreme Court. But for the committal hearing, it's in the magistrate court. So basically, it's decided whether there is sufficient evidence to put the defendants to trial by jury, just by prima facie cases. They're not going to go to the details to find out. To cross-examine. No, it's not that. The question of guilt is not determined. They just say, let's look. Do we have enough evidence to waste a trial, to waste all the time and money, right, and time? So, okay, so that's committal hearing. So magistrate is sort of like executive power to hear that sort of case. It's not a judicial power in that committal hearing. Let's go to the trial. If the accused comes to the trial, the proceedings are commenced usually by indictment assigned, presented by a Crown prosecutor. So, an accused does have a right of silence, and this is very fundamental, and they can exercise that right. So, when the accused is silent, does not mean they are guilty. So the jury can assume the accused is guilty. The right of silence, that's also a very principle of the common law system. Like, I can keep quiet. I don't need to say anything. You need to prove I'm guilty, right? It's quite hard, it's really. Costs lots of money. Okay, commencement of proceedings. A civil action is commenced by the person who filing in the appropriate court or tribunal registry. And you have to serve on the party a document initiating the action. You have to serve. The tricky part about the serving, sometimes the defendant or the respondent, so they're quite tricky. They say, I know somebody's chasing me. I don't want to receive all your documents. I'll hide away. I'll pray, hide and seek. So that's very hard. Then the plaintiff has to go to court again to find another way to serve and go more paperwork to say, I have tried all my means, I couldn't find this person. So in QCAT, if you cannot find the person, you can send via email. So very simple email, you can say, I served the document. So QCAT is very flexible, which is good to use. So anyhow, let's say the parties. And the terminologies of the parties can be different. In federal court and the family court, we can refer to applicant and respondent. If the case go to appealing stage, appeal, then it's called appellant and respondent. So, in the civil cases, how do you call the parties? The case usually is named after parties. For example, Mr. Zhang is suing Mr. Trump. So it's Zhang under Trump. So the civil case is under. So we're almost done. I think I'm done. Okay, let me just check. Oh, okay. Next term. So I've finished. Okay. So, Thank you for your time. I hope help a little bit.